What if I told you you can file a workers' comp claim 26 years after you stopped working, and it would be found timely and you'd be entitled to benefits? Hi, my name is Michael Burgis. I'm a legal certified specialist in California workers' compensation. I'm a trial attorney and I'm the managing attorney of MB&A. In this video, I'm going to show you how. Please like, share, and subscribe to this channel as I'm putting out lots of content that will address a lot of your legal questions regarding workers' compensation. In this case in particular, I'm going to be talking about a case that just came down called Raymond Craig Penrose versus Denver Gold. Essentially, this case is about a pro football player that filed a cumulative trauma claim for injuries he believes he sustained over the course of his professional career as a football player. In this case, 26 years after he had stopped working. Ultimately, this case goes over a lot of fundamental issues that are important to workers' comp, but I want to highlight really one, and that is Labor Code 5412 and the date of injury. This video is going to be discussing how a injured worker who filed a claim 26 years after they stopped working could have a timely workers' comp claim. First off, the controlling statute is Labor Code 5412. And when I start on this, let me first start with what the injured worker's burden of proof is, right? This is what this injured worker had to prove. Ultimately, that is under Labor Code 32081B, and it defines a cumulative trauma injury as follows. Quote, occurring as repetitive manual or physical traumatic activities extending over a period of time, the combined effects of which may cause any disability or need for medical treatment. So that's the definition. So in this case, this injured worker clearly established 26 years later that he had sustained disability and need for medical treatment. And that was the result of his repetitive physical job duties. So he met his burden. Now the next issue is looking at, is it timely? Now, if the defendant is disputing the statute of limitations and claiming that it is untimely filed, they would have that burden. Before you can even get to that burden, you have to establish what is the date of injury. Is the date of injury the last day of injury's exposure? If that were the case, that's a 26-year-old injury, right? So that is where Labor Code 5412 comes in. And let me just quote it verbatim first off. Quote, the date of injury in cases of occupational disease or cumulative injuries is the date upon which the employee first suffers disability, therefrom, and either knew or in the exercise of a reasonable diligence should have known that such disability was caused by his present or prior employment. There's really two functional things here. It's disability and in knowledge of industrial causation. So the date of injury is the concurrence of disability and knowledge it's industrial. Now, the disability is, medically driven, right? This is, they need medical treatment, unable to work, or whatever that may be. The real crux in this case is ultimately determining what does knowledge mean, right? And ultimately, my argument as an injured workers advocate is, unless I'm representing a doctor, my client is a layperson. How do they know when something is industrial or not? They don't, right? And a lot of litigation, but this case is highlighting a plethora of case law, all of which supports that unless this person's a doctor or has medical knowledge, you can't impute scientific medical knowledge on a lay injured worker. So I want to talk about these cases briefly. There's City of Fresno, VWCAB, Chambers VWCAB, Gleason VWCAB, Hughes Aircraft VWCAB, and Kaiser VWCAB. These are all cases that are essentially confirming that you need a doctor to say this is caused by your work to trigger Labor Code 5412's date of injury. So in this case, the date of injury was actually 26 years later. Remember, it's the occurrence of disability and or need for medical treatment and knowledge, in this case, from a doctor that it is caused by work. So the occurrence of that occurred 26 years later, so the date of injury is timely. It's as long as you file within 1 year of the doctor saying this is caused by work, it is timely. Imagine you're an injured worker and you knew that you suffered disability, you're having current disability, current need for medical treatment, and you know that the degenerative disc disease in the back, the arthritis you're having, is likely caused by your repetitive job duties of lifting over the last 20 years, but you retired 5 years ago. This case says, wait a minute, you can file a timely workers' comp claim. So if you're an injured worker or you're an attorney and somebody comes to you and is saying that they believe now, or they're being told now by a doctor that they've sustained industrial injuries, but it was so far ago that you don't think that there's a viable claim, this case tells you there is. So if you believe that you've sustained a cumulative trauma injury and there either is no medical evidence saying that, or it's within 1 year of a doctor indicating that, you have a timely case. You can file a cumulative trauma, and under Labor Code 5412, the date of injury, again, is the concurrence of disability and knowledge that it's industrial. Again, this case is reaffirming the case law here, and it is an amazing case, and it's important that you guys all know about this because, again, there are a lot of benefits that injured workers would be entitled to that they're going to presume that they can't file because it would be untimely. Once again, I hope this video has been helpful. If you have any questions or concerns, we're standing by. Again, please like, share, subscribe as we put out a lot of these contacts. And again, if you have any questions or concerns, our office is standing by. We have the answers, and we're here to help.